Good afternoon, everyone. Thank you for joining us for this installment of the Dean's Conversation Series. I'm pleased to be co-hosting this session with Dean Broussard's office, the Office of Professionalism and Career Strategy. We are so honored that Chief Justice Burke joins us virtually every year for this special program. And let me give you a little bit of her biography. And I urge you to take the opportunity when you have time to look at her full biography because she's such an impressive jurist and individual. She is currently the Chief Justice of the Illinois Supreme Court. She was appointed to the Supreme Court in 2006, was elected in 2008, and then retained in 2018. She started her 3-year term as Chief Justice in October 2019. Before joining the Supreme Court, Justice Burke also served on the appellate bench and on the Illinois Court of Claims. In addition, she served as special counsel for child welfare services. Before attending law school, Chief Justice Burke was a physical education teacher with the Chicago Park District, where she worked with children with learning differences. Having recognized the positive impact of sports competition on her students, she championed the idea of a citywide competition. This competition ultimately led to the creation of the Chicago Special Olympics in 1968 and grew to become the International Special Olympics, reaching tens of millions across 192 nations. She later served as a director of the International Special Olympics and remains involved in the Chicago Special Olympics to this day. Justice Burke, thank you so much for being with us today.
Well, thank you, Dean, and welcome to my chambers.
We appreciate you joining us, and we usually just get to see you, but it's a treat to be able to get to see your chambers. Are you joining us from Chicago or Springfield?
No, this is Chicago, 160 North LaSalle, and I always enjoy coming over to school so I can see the students in person. But this is the first time that you've been able to see where I work. There's 3 justices in Chicago, myself, Justice Tice, and Justice Neville, and we had similar chambers, and our law clerks are here. So this is where I work almost every day.
Great. Well, the first question I have for you is, how is the court operating during the pandemic? And then we had a little exchange about the judicial system and how it's operating during the pandemic. And I think the students would love to hear about the broader issue as well.
Right. Well, of course, when a year ago, when the pandemic really became real for all of us, what do you do with a system that needs to be open all the time? And that's what the judicial branch is. We're a service system for people. And so we had to make sure that we had to be open. We didn't close any courthouses. So portions of the courthouse had to remain open statewide. But because we have 102 counties, we have 102 plus courthouses throughout the state, but not all, and the geography of the state for judicial purposes, it's divided up into 5 judicial districts based on population. We here in Chicago area, Cook County is the first judicial district, and that's the largest. That's why we have 3 justices, and the rest is 1 justice each. But when we had COVID last March, downstate thought we were living on another planet. They didn't have they weren't able to physically see or know about COVID. So we couldn't just say everybody has to wear a mask or we have to close down courthouses. So what the Supreme Court, what we did, because of Zoom, we immediately turned to the Zoom room. Immediately in March, called together all the chief judges, which there's 24 chief justices from 24 circuits, and had other stakeholders, leadership justice stakeholders, clerks of the court, sheriffs, and other of our justice partners come on our Zoom call to say, well, what do we do? So we all drafted together with our administrative office the plan for the state on keeping courthouses accessible throughout the state. And it was all based on the present health of your county, working with your local county health officials. And so up to today, we're still doing that. In fact, we have a leadership meeting this afternoon after we're through, where we meet, every few weeks, again, to see how we're all doing and who's doing jury trials, who's not, who's having outbreaks of COVID around the state. So what we did was for people like myself and some others of maybe my age and maybe a little younger and a little older, we weren't really used to Zoom for anything other than maybe a webinar, but the Zoom room became what we needed every day, all day long for meetings for our court system. So and one interesting story is that we had a leadership meeting of other judges and court personnel from around the state come on the call. And as I look at the screen today, I see you and you see me, but I don't see everybody else. And the first few calls we had with the leadership around the state, I saw the name of somebody, but I didn't see their face. And after the third meeting, a few of them had their face there and said, we made it, we learned how to do it. So those of us of a certain age, we're not going to be left behind. And we are now full-blown Zoom for all our meetings and things. And so I think that this is presently a necessity, but it's also a silver lining. The pandemic is a terrible, awful thing that happened to us. But I think it had us wake up a little bit for a number of things, even personally to wake up at what's important to us, but also to look at how we do business, whether we be a court system, whether it be an education system, or even a private industry. We could really do a lot of streamlining of our work. And we have learned to do that with the Zoom. And the money that's saved by transportation, overnight, housing, food, everything in our system was sufficient enough for the Supreme Court to give grants around the state where counties had no Wi-Fi. If you can imagine a place downstate or in a rural area that had no Wi-Fi in their courthouse, in today's world, they didn't have the infrastructure. So we were able to give grants to that county to put infrastructure of the money we saved from not traveling around the state with meetings. So it is really an eye-opener on best practices.
So it sounds like you can tell the students that the skills they're learning on Zoom are going to be there. They're going to be able to use those post-pandemic in the legal system here in Illinois.
Oh, it's a future and your work product. In fact, lawyers around the state, many of them were thinking, how are we going to do jury trials? How are we going to get into the courthouses? Well, they don't have to. Actually, some districts, at least I think the 5th Judicial District downstate has 38 counties. That means 38 plus courthouses. Can you imagine being a lawyer downstate and having to travel for a status call from one to another? This has been, a godsend for many of them to be able to have a status call on Zoom. And it's less expensive for the client, and it's time saving for the lawyer, and it's better for the system and with the filing. So another thing we were able to do very quickly was together in our group meetings, amend some of the court rules about filing, waivers, electronic signatures, and we were able to do it together as a group to what's best for the system when it became time for that particular county to go to a more strict sheltering and mask wearing or less vibrant courthouse.
We heard from your bio that you were appointed, then elected, then retained. Can you talk to the students a little bit about how someone becomes a Supreme Court justice, the different ways to become a justice, and then how you remain a justice?
Yes, well, fortunately for me, I spent almost 12 years on the appellate court. And when there was an opening on the Illinois Supreme Court, in 2006, Justice Mary Ann McMurrow, when you're a justice on the Supreme Court and there's an opening, you have the authority under the Illinois Constitution to appoint somebody, whether it be a trial court, appellate court judge, or onto the Supreme Court, to recommend somebody for that position. And the Supreme Court weighs in on it and either nominates you or affirms your that position for a time certain. Generally, it's 2 years until the next general election. Now, it's the Supreme Court as well as the trial court and appellate court. It's the same thing. If somebody gets appointed to a position, they have to run in 2 years. If they choose not to run, then they're off the court at the end of that 2-year term generally. So when I got appointed in 2006, of course, I had to run in 2008. We currently have a new judge, one of the 2 new judges on the court, Judge Robert Carter, who's been a judge for 40 plus years, trial judge, appellate judge, and he was recently appointed to take the place of Tom Kilbride, who did not get retained in the last general election. So he took the position of appointed to the Supreme Court for 2 years, but he's also announced that he will not run. So that'll be an open space in 2 more years. That will be a general election. But everyone who is a judge in Illinois, except for associate judges, have to run in either in a partisan election. And of course, once you become a judge, you're not to be partisan. We all understand that. The only other group of judges who don't run are people called associate judges. They get appointed by the circuit judges who vote in that particular circuit. The first judicial circuit is Cook County. There are 10 openings right now, and there's been a posting for whoever wants to be an associate judge had to get an application in by yesterday at a time certain. And there are 245, I think, applications for 10 spots. So between now and another time certain, all those people try to present themselves to the circuit judges in Cook County to lobby them, to say, and have them judges look at their applications and see through, and then those judges pick a shorter list. And then those final people will have personal interviews with the judges, and they will take a vote and pick 10 people. But it's by the elected circuit judges who can elect an associate judge who doesn't run in a general election. So that's how we pick our judges in Illinois. And so I've already been retained 3 years ago for another 10 years.
So going back to the pandemic, we had an audience question, which was, everyone has recently seen the video of the cat filter that's been making the rounds. So the question is, have you encountered any serious problems, technology problems, with lawyers who've appeared before you?
No. We have had no serious problems with lawyers who have appeared before us, technology-wise. I have to say that this last term in January, we were prepared to be in Springfield in person. And on Thursday, before the Monday of the first day of court in term in Springfield, we received a call from the building in Springfield, our courthouse, that somebody there had contracted COVID. So the building was quarantined. So we had to turn on a dime to do all remote, which we've done before. The term before, we were all remote. So we used to it. Fortunately, we were able to do it. But we also have hybrid. We give the lawyers an opportunity to come in for oral argument if they want. We sit on the bench and there's glass between us. The distance between us and the podium is over 20 plus feet. Everybody has to wear, we only allow 10 people in the courtroom at once. The clerks, including the clerks and the marshals and the 2 lawyers, or 3 lawyers, whatever. And they wear masks. until they get up to have an oral argument. They're given their own cover for the microphone. It's a little sponge cover that they have to use. And then when they finish their oral argument, they take it back off. And so the next person uses that. So everything is very, very sanitary, wiped down between at the podium between oral arguments. And the hybrid consists of some lawyers choose not to come down. So we give them the opportunity to give oral argument by Zoom. And so we have 2 coming up next week, or I mean, I should say in March, that are doing Zoom.
It's great that the court's been able to be so flexible with the attorneys. I know they appreciate that.
Well, it's important. We should be flexible on a lot of things. I mean, nothing is, well, why not? I mean, it should be, we're a service, and we have to remember that we're public employees servicing the public, and we need to accommodate them for access for justice. And that's probably primarily in our minds as a court, universally us, the Supreme Court, is access to justice is probably our #1 problem right now. It's a good problem in some ways because because we're focusing on it and we're giving opportunities for more people to have access in so many more ways, and hope to do a lot more coming up. But that's what we have to keep in mind, is who comes before us, our consumers, so to speak.
And you and I talked offline about how much more affordable for clients appearing by Zoom is. You don't have to travel and stay overnight. You can just charge your client for the actual appearance.
That's right. And things move faster. Your status calls, and there's more efficiency. I mean, there's an ability to control the docket if you're a judge a little more. But it takes not just the judge, but it's all our justice partners, the state's attorneys, public defenders, and the clerks of the court, the sheriffs all around the state have really stepped up and have collectively and collaboratively made the justice system more accessible than ever before.
So some students might not know that the Illinois Supreme Court has a role in attorney licensing.
Oh.
Could you describe what that role is?
Oh, I think they know before they start. They worry about the bar exam and have nightmares from the time they become a law student. Bar exam. Yes, under the Constitution, the Illinois Constitution gives the authority to the Illinois Supreme Court to regulate and administer who should be a lawyer in Illinois, both becoming in as a lawyer and also staying a lawyer in good standing. So the Board of Bar Admissions is, as you well know, because you've been active your whole career with bar admissions issues, it became pretty difficult, I think, to think about what are we going to do about having a bar exam in Illinois and around the country. But it's worked out. In fact, I believe the statistics with the remote bar exam this time was higher than last time. And I really think that the part of it is a comfort zone. As you were saying, the students that are in school today have been used to using technology, and the world is needing to use technology. So we just have to come into line with the idea of that in so many ways. I have one of my grandsons is 2 years old, and some of the parents were talking about, well, what's this poor child, they're doing all remote and everything. I said, there are some downsides to that, but you know what? The good thing is being a second grader, say he's a second grader, he knows now in second grade, as your students know now, that their work in the future will be mostly remote, or some aspect of it will be. So it's actually a good thing he starts out this way in doing a lot of things remotely and being on his own and figuring things out. But in terms of the bar exam, I know we're going to be having another one, and it's going to be remote. And a lot of the so-called technology pieces will be fine. They got through it. As a matter of fact, if you looked at some of the things that went wrong with in-person compared to remote, it equaled. There wasn't any more problems with the remote than they were with in-person problems that occur with in-person. And actually, I think because the proctors is the screen and they're being watched. With a room of 1,000 people, how can proctors watch everybody?
And I assume by the upcoming exam, you mean the one later this month. I
Yes.
haven't heard July 2021 announced yet as remote.
Well, I think they're planning. We always tell plan for both. Be ready to go on a dime because we don't know what July 21st is going to be. And you know, if we had a crystal ball, we would. But we don't want to wait too long either.
Yep, I saw DC just announced remote for July.
Yes, and I think we probably will too.
So we have a couple of questions about externships, and you take externs from John Marshall. Will you talk to us a little bit about what you look for in externs and what students externing with you or other justices on the Illinois Supreme Court do?
Sure. Yeah. Well, right now I know that Justice Tice takes some externs and I take externs, but I've always taken externs even when I was on the appellate court because I think it's a great opportunity for law students to have a view from the bench of what lawyers do and don't do and what judges do and shouldn't do. And I think that just view is very important. And what you say counts and what you write counts. And the most important thing I look for is their willingness to learn and they have to be able to have some experience writing, of course, but most students do. But I really just look for the fact that they want to have this experience. And I'm surprised that more people don't actually sign up for it because it's a great opportunity both in the appellate court and the Supreme Court, and especially for credit, because you do a lot of writing. You learn from my law. I have 4 law clerks. You learn from them. You learn the law. You learn how to write and think, and what should be said and what shouldn't be said in a practical way. Because they're reading briefs, they're reading PLAs, and they're looking and say, well, why did this lawyer say this, and they shouldn't have said that, or why did they put this in? So I think it's a good experience.
And if anyone is interested in a judicial externship, including an externship with Chief Justice Burke, please see Professor Bess.
I was going to say, Megan
coordinates that
Bess, she's the director of your externship program. Yes, see her.
Absolutely
We need an application, a resume, a cover letter, and a transcript. And she knows. I mean, she's been very helpful.
So we have a question from a student who asked about some challenges you had going to law school as a second career student and how you overcame them. So if you could answer that and also tell us a little bit about how you came to go to law school after being in
Oh, wow. Well, you did say when I was involved with Special Olympics, you gave a year, so they must know how old I am. So, but I was actually a college dropout in 1963. I was not a very good student at all in grammar school or high school. And the school that I was going to in Chicago, George Williams, moved to a suburb, so I had to drop out. So that's why I kept working at the Park District. And I did become very knowledgeable about people with learning disabilities. But after I got married and had 3 children, my husband kept on saying to me, you should really go back to school and get a degree to help the vulnerable people in our society that you care about. So I went to DePaul University School for New Learning, and I had 3 little children. And so I thought I was through with school. I did get my teaching certificate, but I still stayed involved with Special Olympics as an advocate. And then he kept on telling me that I would be a better advocate for people in our society who were vulnerable if I were a lawyer. Well, that really piqued my interest, but I didn't think I could ever do it because, like I said, I'm dyslexic, number one, and I'm not a really good student. But I was provided. He made sure I had a tutor, and I started law school with 4 children under 10. It's not something I really recommend to everybody, but it doesn't mean you can't be done. It can't be done. by the time I started school, I fell in love with the law. I mean, reading the cases and learning about it, I just couldn't let go. And so I was 40 years old when I did finally graduate from law school. So, I mean, I know it's not a real career goal, was never a career goal. And I know one of the questions you had asked me before was, what do you suggest, if somebody wants to be a judge? And I thought back that I never thought I wanted to be anything. I just liked what I did. You know, in my first life, being a phys ed teacher, I loved sports. I loved teaching. And I just thought it was a really important thing to just like what you do, love what you do. But I only got my education further because I wanted to continue doing what I like to do, but be in a better position to help more by having a college degree and being a lawyer, in that love of my life, which was working with children with disabilities and people who are vulnerable in our society. So when you think about the students you have now and the students that are online, be open-minded. Don't have the one goal of wanting to be a judge someday, because you miss what happens along the way. You're going to be an extern. You're going to work for some legal aid society. You're going to be out in the community working with vulnerable people, and you're going to see what else is available where you might want to spend your time. But you first have to be a good lawyer before you consider being a good judge, because that's what'll make you really a good judge, if you've been a good lawyer. And by being a good lawyer, whatever area you choose, get the experience. And that's why judicial externships are great. Working in a social service agency as an advisor, not as a lawyer, but as an advisor while you're in law school, to get experience. Seeing what's out there. And you may find you have a whole different track.
We have a couple of questions asking what your judicial philosophy is.
My judicial philosophy is to get it right, the facts to the law. That's it, nothing more.
Do you consider yourself a textualist or in some other category?
No, I don't. Absolutely not. I really don't. I couldn't tell you. I mean, it's maybe somebody else could tell me what I am if they read my decisions. But every case is totally different from any other case we've had. Every case has nuances that we haven't seen, and we just have to make sure we get it right. And all of us on the court, it's a very collegial court. We really, really work hard on making sure what we've done follows the law to the facts of this particular case. And that's the other thing, is that we decide which cases we take. Whereas the appellate court, they take everything. They have to. But we make decisions on which cases we take. And there used to be the death penalty in Illinois, and those came right to the court, the Supreme Court. It didn't go to the appellate court at all. And constitutional matters often bypass the appellate court, come to the Supreme Court directly. But other than that, we just take cases that we think have policy needs to be addressed. Laws is conflicting between the judicial districts, and we need to clarify it. Or there's some statute that's been found unconstitutional, or or we decide whether it's constitutional, and it's a matter of great importance to the general public. Those are really the kind of the standards. There's no golden rule or written rule what we take. We see it when we see it. We know it when we see it.
Do you use a cert process like the Supreme Court, where the different justices evaluate each case and then you have to have a certain number of votes to accept it?
Well, you have to have 4 votes to accept it. We look at all the petitions for leave to appeal. There's several hundred, like right now, I think there's about 350 for this term. So each one of us look at them all. And of course, it's a one-sided petition. It's the appellant's petition. And based on that, we determine whether or not we would take the case. And we vote electronically before we meet in term. And some of the cases get 4 votes right away. Some get none. But this is an interesting aspect of it. It has to have 4 votes. If no one, I mean, if I was the only one who wanted to take the case, I could put it on the agenda to argue for that case. If it's say, for instance, a child welfare case, I'm very interested in that area. Not that I'm interested in others, but that's one area I am. And I would be able to bring the case up to all my colleagues in term, talking about the petitions for leave to appeal. And I would have an opportunity to explain to them why we should take the case and they should change their vote. All I need is three more votes. And it happens. So who would think that I could be an advocate? I never thought I could be an advocate again, except at that table for petitions for leave to appeal. That's the only other time I can be an advocate now in my life. So when it comes to legal matters. So the other time is if one judge recuses himself from a petition for leave to appeal for whatever reason, and the case only has 3-3, then it's considered denied or dismissed, and the appellate court's ruling stands whether we think it's good or right or wrong.
Let's turn to briefs and oral arguments. And to lay a foundation for a question we have, could you first talk to us about the role and influence of written briefs versus oral arguments at the Supreme Court level?
Both are extremely important. And that's why one of my wishes is that appellate courts would take more oral arguments. But you know, when you, as I said, the appellate court can't choose which cases they take, but they can choose which ones they have for oral arguments. And it's always helpful to listen to the conversation on a matter. And not necessarily quoting cases or anything like that, but the conversation why this case should be reversed or should be affirmed. And the written word is the key in the briefs. Because judges you get influenced by how it's written and how well it's written and how poorly it's written. And what stands out is the poor one. And if it's just so argumentative and not based on logic and addressing the facts, you have no chance. It's like if you have a petition for leave to appeal, it's a really unique area of the law to grab our attention. You'll never get to the Supreme Court if you can't write consistently and coherently and get it down and to get our attention. That's why this case, and what ends up happening, it's more in a conversation that needs to be said in briefs, not just citing the cases. It's the conversation why this case over all others and other cases needs to be addressed in this way. And that's why oral arguments are important. So often, and we were discussing this not long ago, my colleagues and I, how often is it that an oral argument changes your mind after you come off the bench? Quite often. There are times when I've gotten, and my colleagues have gone down the steps after oral argument and said, well, that was a revelation, you know, that just, I mean, really. And then we do an impression vote right after oral arguments, which is like, we haven't really got into the records, or gotten into the law very deeply right after, you know, oral arguments. The cases are really much oraled on just the briefs and some little bit of research by the judges, very little, just maybe the seminal case in the area. And so you have some sort of a thought how you might be. So the impression vote is just based on kind of like gut feeling and what you heard through oral argument. And it really sometimes changes your mind, totally. So both of them count a lot because you have to capture our attention first to get into the Supreme Court and continue that with the good briefs. And then oral argument, which is granted to everybody, have a good conversation with the court.
And the question we got is, if you're not experienced in delivering oral arguments, what are some pieces of advice you might give those less experienced attorneys who are going to appear before you?
Well, if you are an attorney and you're in a courthouse, you have to argue motions, you can do trials, and just be able to have conversations with your friends, your law student friends, is do some argue a case that you're, I mean, just take a side on one issue and be able to convince the other one. And that goes back to another question you asked earlier about listening. I think it's such a gift to be able to listen. Everybody said it's a gift to be able to talk. Well, in today's world, it's more of a gift if you really pay attention to somebody and listen to them. That is a gift to the speaker. So if somebody's really paying attention to you, you will, be able to convince them or get your point across. But that's why you need to practice in conversations daily, no matter what the topic is. It doesn't have to be about the law, but you should have a style of convincing someone in a very polite way. Never talk to somebody, I don't care what the topic is. It's about Snickers bars. What are the ingredients of a Snicker bar and why this ingredient is better than a Musketeer bar? And discuss those kinds of things and try to convince someone that this is really better than that. And in a very polite, congenial way. Is the best practice I can say. Everyday speaking, because you can't. A leopard doesn't change its spots, you know what I mean? If you're always abrasive, if you're always talking over somebody and you know they're not listening, is because you're not trying to get to them. You're not looking them in the eye, and you're not saying, what can I say to you? What do you want me to tell you? Have a conversation more. And that conversations with the court are really important.
I know we have some brand new law students with us, and I would encourage them to get online and watch some either recordings or sometimes there's live streaming of oral arguments. But one thing they may not understand, they may have the impression that giving an oral argument is giving a speech, and they may be upset if someone interrupts them. What I'm hearing, a big piece of advice from you, is watch for the judges, let them ask the questions, because they're really going to focus on what concerns them about the case or what they really need to know to decide the case. So don't worry as much about getting your prepared argument out.
Right.
That fair?
That's absolutely true. And don't be disappointed if they don't ask you questions. They're listening. We're all listening. But they just want to hear what you have to say. So that's why I say the conversation about your case is really important, so that we understand everything. And there's things you know your case really well, but we don't. So it's your chance to educate us about something we need to know to decide the case in your way. So you should be telling us about that. I can remember once when I was in law school, I had a professor who took trial ad with, and he was telling me, that's a he, of course, I'm saying that, was telling me, you have to listen to what the judges have to say, and it's not about what you want to get across, just what you said, Dean. These are the points. Yes, you have to have points, but once a question gets asked, you need to dive into that question. Well, that particular professor, when I was on the appellate court, had a case in front of me. And I said to my colleagues, it was a criminal matter, I said, I'm so nervous because Professor so-and-so was my teacher at trial ad, and now he's appearing in front of me. I hope I asked the right questions, and things like that. I was really nervous. And I said, this isn't really a good case, my first reading of this. I don't really think he has much of a case, this, that, and the other thing. And they said, well, maybe we shouldn't have it oral. And I said, oh, no, we have to have it oral. We have to have it oral. I want to be able to have my professor ask me questions. So anyway, the professor gets up there. I mean, my colleagues and I had said, well, maybe there's a chance on on subject number 2, issue number 2. And I said, okay, so I did all my research on this issue number 2 because that's what he'll probably talk about most. So I wanted to ask some really smart questions on issue number 2. He got up there and he said, I am going to stand on my brief as to issue number 2 and number 5. All my questions were on number 2, you know what I mean? It's like, but that was one of the rules. Don't tell the court what you're going to do. Let the court ask you. So so afterwards it was all said and done and he didn't do well on the written opinion, but he said, what went wrong? And I said, you told us what to do. You told me not to ever do that.
That's funny. Another thing I was going to suggest to our student, who I believe might have been a first-year student who asked the question, is if you're not as experienced in giving oral arguments, you need to prepare. You need to prepare by watching other oral arguments
yes.
and knowing your case inside and out and knowing the record inside and out. That level of preparation, even if you don't haven't given as many oral arguments, can really sort of even the playing field. Is that something you'd agree with as well?
Oh, absolutely. I more than agree. I really affirm that for sure. You have to know your case, and you have to be able to navigate what the question to come back to where you want it to go. And so you have to really know the facts. And I really always say that the facts are the law is the law, and everybody, there are cases that really are on point and you have to get around it, but your facts are different. So you have to be able to bring the law into your facts here, and so that you have to know those and tell us what you think is important, not what you think.
Someone is asking, personally, I think this will be a difficult question to ask. So I think we will understand if you say, I'm not sure, but I'm going to ask it because it ties into what we're talking about. Are there any recent oral arguments that you would recommend students listen to? Have you heard any really good ones?
Well, last term, I mean, by the time a case gets to us, let's just say that, the briefs are pretty good. The oral arguments, most of them are terrific. So you can go on our website and you can see any kinds of cases that you want to see, and pick a topic. But the lawyers that appear in front of us are terrific. And you will see pretty much the best of the best. Now, sometimes you'll see a trial lawyer try to argue his case in the Supreme Court or her case. Sometimes it's okay, and sometimes it isn't. But there is a clear difference between a trial lawyer and an appellate lawyer in how they deal with things. And that I'm trying to think. I can't think of the case off the top of my head where that happened recently. We don't always know if that lawyer had the trial, but most of the lawyers that appear in front of us, there's a smaller group.
They're appellate specialists.
They're appellate specialists. Yeah. But watch. And, another thing I recommend too is to go into the Daly Center, the 26th Street. And there are trials going on now. Most of them are bench trials, but there's Zoom. At Bond Court, you can go on YouTube and watch it at 26th Street. And that's interesting too, but you should try to get inside these courtrooms for some of these things eventually to listen.
We got a follow-up question about whether you could give some more examples about differences you see between people who are primarily trial lawyers and those who are appellate specialists.
Oh, there's a big difference. The trial lawyer is more of an actor in many ways, and emotional, and is speaking to 12 people, generally a jury. And it's a different synergy that he or she needs to make contact with that jury, and make those people feel that he's talking to each one of them individually. Like say a conversation with the jury is that what it's like in your neighborhood on an issue. You've experienced this. And so there's that kind of a conversation. By the time that transcript is in the Supreme Court and the appellate court, but you don't really get the feel about the emotion that a trial lawyer would have. They know their cases very well, but they're totally advocate. They don't really, except in closing arguments, touch on the other side. The other side will tell you this or the other side to do that, but that's in opening and closing. Whereas appellate and Supreme Court advocacy is where you do discuss the other side and why it's wrong. And you get into it and you talk about the facts just don't fit into this, or the cases are on the wrong rail here. So it is a totally different kind of and you're arguing to 7 people or 3 people on an appellate court. And it's less emotional, but it's very precise. You must be precise with your discussion.
Because I know we have many of our new law students with us, could you take just a few minutes and talk about the court setup in Springfield? Because I really think that the way the court operates when it's in Springfield is so unique with your different residential quarters.
Oh, sure. Yes. Well, most people don't really know this. And I did know, but just tangentially. Illinois has had a long history of Supreme Court, 1818. It's been in different counties and different cities, Mount Vernon, Kaskaskia, and ends up in Springfield, where the Illinois Supreme Court is. Now, originally, the old State House, the Supreme Court was, it's in the Capitol grounds now, and it's restored, but with the legislature and the Supreme Court were housed in the same building. And that's not unique. It's something that most states have, where their capital and their Supreme Court were together. So when the new Capitol in Springfield was built, the Illinois Supreme Court was housed in this Capitol building, which in 1907, they were still in the Capitol building. But and as the story goes, there's this story that I think is true, where the justices from the Illinois Supreme Court were very friendly with the legislature, and in Springfield, they would go out for dinner because the term would 2 or 3 weeks, and they would live in hotels and everything else. But there was a card game one night with the governor and some of the Supreme Court justices and some legislators, and the governor made a wager. If I lose this game, you get your own building. So in 1908, the Illinois Supreme Court was built. It's across the street from the Supreme Court. The Supreme Court room in the Capitol is now the Senate hearing room, and we have our own building. But it was very visionary when they built the building, that because the justices had to travel from all over the state, 5 judicial districts, and be together for 2 to 3 weeks, 1, 2, or 3 weeks, whatever it would be more convenient and less costly if they were housed in the Supreme Court building. So the 3rd floor of the Supreme Court building contains 7 bedrooms, where suites of bedrooms, where the justices have been living since 1908. And at the time, the law clerks would go down to Springfield with each law clerk would go with each one of the justices, and they would have their own room and on the 3rd floor. So since 1908, the justices during term live together. We take all our meals together. We do all our work for however long the term is. And now our law clerks don't come down, but we have, unfortunately, marshals that come down with us. But it's a real interesting concept. There's only one other state that did it, and that was Missouri. And the rest like in Wisconsin, I know my friend Shirley Abramson, who just passed away, she was the chief judge. The judges got elected from the whole state. Fortunately, the geography of our state is well thought out. So we have at least geographical diversity. We always have somebody from Southern Illinois, Central Illinois, Eastern Illinois, Western Illinois, and the largest population by population. We always have so many different people we don't even know, come to live together for a term. And it's very, like in 1908, the first person to move in to the room that I moved in when I came on the court in 2006 was James Cartwright. James Cartwright moved into this particular suite in 1908, and he stayed there till 1923. And he was well known for a number of cases. One of them was the case that the term forever open, free, and clear, about keeping the lakefront free and clear. A. Montgomery Ward had been sued to make sure that the lakefront was open, free, and clear. And James Cartwright wrote that case. He also wrote another case at the Alton School case, which was Alton, Gregory, Illinois. Had wanted to segregate the schools, and the Supreme Court in Illinois, before a number of the cases, ruled that it had to be integrated. So, I mean, the history of our Supreme Court is geographical, and we end up being very close friends.
The very first question we got is one I almost always ask near the end, and that is, what piece of advice do you wish you had known right out of law school or early in your career, that maybe you didn't know?
Yeah. Wow, I mean, that's a real hard question. Well, I think honesty and truthfulness. It's not that I didn't know that, but how important it is to be when you are a professional. Everything you do, your personal life, everything, you have to be honest and truthful, because that's your reputation, and that's the reputation that ends up being, other lawyers are tarnished with it if that doesn't happen. So the advice I would say is, and it's not something we didn't know, or you don't, no one, I mean, everybody knows this, but it's really important. You have to be able to trust and be trusted. You have conversations with people, you have to be able to trust them, and they have to be able to trust you. And in your writings, you have to write truthfully and honestly, and not try to wash over things. Just, if something is really against you in a case, just put it up there and say, this case says this. However, we distinguish it because of X, Y, and Z. It's to get it out there right away. But I just, besides listening and empathy, trustworthiness.
You know, students know that judges hear cases, they read briefs, they draft opinions, but tell us some of the other things. We've gotten into a couple of little areas like attorney, well, not so little, but attorney licensing. What are some other things that justices of the Illinois Supreme Court do on a day in and day out basis?
It's the administration. We have supervisory authority over the entire judicial system in Illinois. So we have to worry about budget. We have to worry about personnel, HR issues. We can't do everything alone. We have committees and commissions. The Attorney Registration Disciplinary Commission helps regulate the attorneys, which is our job ultimately. We have the Board of Bar Admissions that helps set up the bar exams. We have to have people to volunteer to do that. We have to oversee all those committees and work with the legislators regarding budget items, making sure they understand the reason why we need more probation officers. And that's why that money should go for that. And working with county officials, health issues. I mean, the pandemic is a good example. All the justice stakeholders, clerks of the county, sheriffs, health officials throughout the state, we all have to work together, and with legislators. We even have law school for the new legislators. We have a program for them so they understand what it is that the Justice Department expects in their drafting of legislation. Of course, we don't want it too good, otherwise we'd have no work. However, but to understand what we look at, so they understand, they know what they should be doing. And then we have oral arguments where we invite the legislature and executive branch over when we have a constitutional issue, so they know that we read the Senate hearing records, and we read all that, and the Enabling Act, so they know that whatever they say, it should be clear. So we don't have to, second guess them, be ambiguous. Well,
And
a good
then-
example is the order on COVID. The judicial branch isn't included. In 1C, it says legal. What does that mean? What does legal mean? Does that mean the judicial branch? Does that mean judges? Does it mean sheriffs? Things like that. We're frontline, essential workers. Courts have not been closed. We stayed open the whole time. Courthouses have people there every day.
And then you also make appearances and go to receptions. And
Oh, yes, we do.
visit bar
Yes, we do.
associations. I know you're
Yes.
busy. We're almost out of time. We have a couple of more questions in the queue, so maybe we can hit those quickly. One is, it seems courts are increasingly politicized in the media. Are you concerned about the public losing faith in the courts due to the political environment, and what might lawyers be able to do to help build and maintain trust in our judicial system?
Yeah, that's a very big problem, because judges really can't speak out in many situations. It might be a case that's pending, one that we're going to have, or if I spoke on some issue, somebody's going to think it's my opinion, and down the line, if that might come back to haunt me if I speak on something in a situation like that. That's why judges have a hard time responding to what's said, even if it's misinformation, which 99% of the time it is misinformation. People talk about a case, and it's not really what's happening in the case. It's nothing to do with it. And it's a very difficult thing, and that's why we need lawyers out there to set set it straight for us, for the judicial branch. So I want you to belong to bar associations and speak out on these issues and not let misinformation be out there. You have that opportunity, and you should have that duty to do it, because this is a democracy. We can't let our justice system be maligned like that. We won't get good people to be wanting to be in public service, to be a judge. And that's another thing. I mean, if people are maligned all the time, and this happens in elections, what happened to Justice Kilbride was absolutely not the truth. They mentioned something in some of those dark ads about a case. That we never had that case. You know what I'm saying? So how do we respond to that?
Final question. It goes back to some of the themes we were talking about the differences between trial and appellate specialists, and also about honesty and truth. And so here it is. It seems like lawyers may be hesitant to be transparent and forthcoming about cases that may go against their argument. So from your perspective, when an attorney is transparent, does that provide more credibility to that attorney's argument?
100% credibility. Be honest. Get that out there. That could be the first thing you want to talk about. I know my opponent's going to talk about this, but it really has nothing to do with this case, and explain to us why. Because if I'm reading an appellate brief and you don't even mention it, and by the time I get to the appellee's brief, I'll say, well, why didn't they even mention it? I would have had time to think about it in terms of their case if it's in that brief. Now I'm at the appellate, I've read that, I'm at the appellee's brief, and I'm thinking, well, that wasn't honest. You should warn me.
Well, Justice Burke, we are at the hour. Thank you so much. Thanks to the audience for such great questions.
Yeah.
We appreciate you being with us and sharing your wisdom and insights. And we wish you a wonderful day. And we hope you remain very safe throughout the pandemic.
Thank you, Dean, and thanks Justice Fassard too. Thank you.
Absolutely.
Okay.
Definitely thank Justice
Okay.
Burke.
Thank you. Bye, everybody.
Bye, everyone.
And apply to be a law clerk, extern.
Bye.
Bye-bye. Thank you.